A police officer jumps onto a moving car during a routine traffic stop and shoots the driver dead. The Supreme Court already ruled 9-0 that the lower courts got it wrong. They sent the case back with crystal clear instructions, and then the lower court came back and ruled the exact same way, just using a different excuse. Now this case is heading back to the Supreme Court a second time, and what happens next could redefine when police in America can legally use deadly force against every single one of us. Let me break this down from the beginning. It started with a minor toll violation. An officer pulled over a man named Ashton Barnes, a routine traffic stop. The officer ordered Barnes out of the vehicle. Barnes opened his door like he was going to comply, and then tried to drive away. Here's where the split-second decision gets complicated. Instead of stepping back and letting dispatch handle it, the officer jumped onto the door ledge of the moving vehicle. He was hanging off the car as it drove away, and from that position, a position he chose to put himself in, he drew his weapon and fired 2 shots into the car. Ashton Barnes was killed. His mother filed a federal civil rights lawsuit, arguing the shooting was excessive force under the Fourth Amendment. The lower courts sided with the officer, using what's called the moment of threat rule. Under that framework, courts look only at the precise second the trigger was pulled and completely ignore everything that led up to it. Using that narrow lens, both the District Court and the Fifth Circuit said the shooting was justified. But the Supreme Court stepped in, and in a 9-0 unanimous ruling, every single justice agreed the moment of threat rule was thrown out. The court was clear: excessive force cases must be evaluated using the totality of the circumstances. Everything matters, the full picture, not just the final split second. The Supreme Court sent the case back to the Fifth Circuit with direct instructions: apply the correct standard and issue a new ruling. And then something extraordinary happened. The Fifth Circuit didn't hold new oral arguments, didn't request updated briefs, didn't send it back to the District Court for a fresh look at the facts. Instead, a 3-judge panel quietly issued a brand new decision and ruled in favor of the officer again. Same outcome, different theory. This time, the court said that because Barnes tried to flee in a vehicle, he created a risk of danger to others on the road, and therefore the use of deadly force was reasonable. Think about what that reasoning actually means. Under that logic, anytime a suspect flees in a car, anytime an officer could potentially justify using deadly force, because you can always argue that a moving vehicle poses some risk to someone somewhere. The family's legal team says this effectively creates a new rule that goes even further than what was already in place, and it directly contradicts decades of Supreme Court precedent. Back in 1985, the Supreme Court ruled in Tennessee v. Garner that simply fleeing is not enough to justify deadly force. An officer must have probable cause to believe the suspect poses a serious threat of death or significant bodily harm to others. Flight alone doesn't clear that bar. It never has. But according to this new petition now sitting before the Supreme Court, the Fifth Circuit just quietly lowered that standard. Risk of flight is now apparently enough. And if that reasoning stands, the Garner precedent that has protected Americans for 40 years gets gutted without a single congressional vote. So the family is back at the Supreme Court, just months after winning there unanimously, asking the justices to intervene a second time. Here's where things stand procedurally right now. The defendants filed a waiver saying they don't plan to submit a response opposing Supreme Court review unless the court specifically orders them to. That move signals they believe the court won't take the case. But the Supreme Court didn't wait for a response. They've already scheduled this case for conference on April 24th. That's significant. The court set a conference date on its own without ordering a government response first. Now we watch to see whether the justices demand that response before the conference date or whether they act on what's already in front of them. If the Supreme Court takes this case again, and that's a real possibility given what the Fifth Circuit just did, it would be one of the most direct rebukes of a lower court in recent memory. A court being told 9-0 that it got the law wrong and then coming back with essentially the same answer using different words. The core question is this: can a police officer use deadly force simply because a suspect is fleeing in a vehicle, even when that officer voluntarily placed himself in harm's way to begin with? And does risk of escape alone now justify lethal force in America?
The Supreme Court already weighed in once. The Fifth Circuit didn't listen, and now the highest court in the land has to decide whether it's going to let that stand. April 24th is the date to watch. The moment there's a development in this case, we'll have the full breakdown right here. Subscribe now so you don't miss it, because the outcome of this case affects every American's rights, not just gun owners.